নমস্কার বন্ধুরা, ওয়েলকাম ব্যাক টু এক্সাম ইনফরমেশন পয়েন্ট অফিসিয়াল ইউটিউব চ্যানেল। তো বন্ধুরা, তোমরা সবাই জানো আজকে 31শে মার্চ তোমাদের কিন্তু কেসের ডেট ছিল। তো বন্ধুরা, ইতিমধ্যে কিন্তু কেসটি উঠেছে, কেসের আপডেট ইতিমধ্যে চলে আসছে, আমি তোমাদের সংক্ষেপে বলছি। তো বন্ধুরা, কেসটিতে কি বলা হয়েছে আমি কিন্তু তোমাদের লাইভ ভিডিও দিয়ে দেবো, তোমরা কিন্তু দেখে নেবে। তো বন্ধুরা, আজকে কেসটি উঠেছে, ঠিক আছে। আমাদের যে পিআরবির উকিল ছিল কল্যাণ ব্যানার্জি, তিনি বললেন যে এই কেসটি সিঙ্গেল বেঞ্চে ডিসমিস হয়েছে, অর্থাৎ তাকে যেন আর সুযোগ দেওয়া না হয়। এর ফলেও কিন্তু যারা আর কি পিটিশনার, ঠিক আছে, কেস করেছে যারা, তারা কিন্তু কী হলো, তাদের বক্তব্য যে একই দিনে একই মেশিন কিভাবে সকালে হাইট মাপলে একটু কম হয়ে যায় এবং বিকালে হাইট মাপলে একটু বেশি হয়ে যায়, সেটা কেন হচ্ছে। এবং এই কেসটি কিন্তু পিআরবির যিনি উকিল তিনি কিন্তু ডিসমিস চেয়েছেন, ঠিক আছে। তো ইতিমধ্যে কিন্তু আপডেট চলে আসছে, একটা ভালো নিউজ আসতে চলছে, তোমরা নিজেরাই ভিডিওটি দেখো। এবং ভিডিওটি কিন্তু আরও একটা নেক্সট ভিডিও আসবে, এমএটি 303/2026, এটি কিন্তু তোমাদের এমএটি 295/2026-এর। তো ভিডিওটি প্রথম থেকে দেখো, ঠিক আছে, সম্পূর্ণ আপডেট তোমরা নিজেরাই দেখবে। তোমাদের কিন্তু গুড নিউজ আসতে চলছে আজকে, কিছুক্ষণ পরে কিন্তু গুড নিউজটি আমি চ্যানেলে দিয়ে দেবো, অবশ্যই দেখবে। জয় হিন্দ।
You are clear to us. Saying all right, you prefer an appeal, you give the ground, we'll consider it, and if required, if we allow the appeal.
So according to you, the scope of an appeal is the PMT, not the measurement itself.
Yes.
So if there is anything infirmity to be highlighted about the PMT, then appeal is to be filed.
Yes.
If I see that there is an infirmity, I may direct for measurement of everyone.
No, even,
Or I may not direct for measurement of
let's
anyone.
assume that he is telling something. Whether he is 1.61 or 1.6,
That is immaterial.
That is not the, this is not the court's domain, it is domain with me.
They have understood.
Now, therefore, appeal which ground he is taking, that I have to consider first.
So therefore, we are saying if he can highlight an infirmity in PMT,
Yes.
then all the parameters can be remeasured.
Yes.
If he does not highlight, according to you, nothing can be measured.
Absolutely correct.
That is your case, perhaps.
That's my case.
Yes.
Only I am objecting only with this measure. Do it with measurement. That is I am objecting.
Right.
And yes, at page 140, kindly see I have given the everyone side. Okay. Just I am ignoring. Only to this. And decision ignored. And minute after this order has been passed, before another bench, kindly see the order which has been passed. Since that the single bench has dismissed the writ petition. Kindly come to me at paragraph 8. In support of the submission, the petitioner rely on the order dated February 10 to the passed by this court in WS transfer recruitment, wherein similarly placed candidates found unfit in PMT were permitted to prefer appeal before the appeal. Reliance has also been placed on the order dated September 19, 2005, passed by the Honorable Delhi High Court, wherein the court passed a question as to why even 24 hours was not granted to the candidates to appeal. Again, the reason is run so and so. And then Miller kindly come to that is the Miller paragraph, kindly. Paragraph 15. I have heard the submissions made on behalf of both the parties and have perused the materials placed before the court. From the documents annexed to the writ petition, it appears that PMT of the candidate was conducted on separate dates in respect of different candidates. These are candidates whose PMT was conducted on January 10, 9, some on January 20, a few on January 14 and January 17, 2023. The cause of action for final writ for individual candidate arose on diverse dates on the date they were found unfit in PMT. The dissatisfied candidate had the right to appeal on the very same date, and no appeal is entertainable in future. The petitioners allege that they were prevented from filing the appeal on the same date, but there is nothing on record to prove such allegation. The instant writ petition has been filed bona fide on just so and so. The report filed by the Deputy Superintendent of Police Administration of the West Bengal Police Recruitment Board clearly mentioned that the height of the candidates was measured by a standard operating machine with no human intervention. All the candidates were measured by the same machine, and the mode and manner of measurement of all the candidates was the same. The petitioner may have measured themselves in other government hospitals, but they have been found to be a requisite height. The court is not aware as to whether the earlier measurement made by the petitioner or the one of the date of the examination is proper, as it appears that a standard machine was used to measure the height of each and every candidate who participated in the measurement test. Accordingly, the court is not inclined to accept the prayer of the petitioners to get themselves remeasured by any other machine or by any other authority. Equally and uniformity has to be maintained in all public recruitment process. The dissatisfied candidate also do not have a right to prepare appeal in such a delayed point of time. In a public recruitment process, certain steps have to be followed for eliminating candidates for the purpose of selecting the best one. The court usually does not interfere in the recruitment process unless there is a specific allegation of illegality or malafide. In this instant case, nothing has been pointed out to show that there is malafide or there is an apparent illegality on the part of the respondents in conducting PMT by the said machine. It is also not the case of the petitioner that the machine by which the height was measured is a defective or faulty one. If the same standard machine has been used for measuring height of all candidates, there is no reason to depart from the same and allow the petitioner to be measured by any other machine. The same would infringe the provision of Article 14 and 16 of the Constitution. A well-reasoned order has been passed by Justice Sen. In fact, not only appeal, the machine, etc. The place of measurement to protect ডেটগুলো এখানে অ্যাপিল ফাইল করোনি। So you have not filed the appeal, that is admitted. Similarly, will not the order. Similarly, another judgment.
We are just trying to ascertain the facts. You, for whatever reason, you could not file the appeal on that day.
Item number 10.
Item number 9.
না 9টা পরে করো, 10টা হয়ে যাক।
Now, only question is whether so this is following the earlier judgment, perhaps. Yes. Illegality for ballot. That will ballot in the date of this ballot. I will show ballot those which is not part of the record and obtaining once beyond the record we do not, because we don't appreciate such practice at all. The measurement of this lady at the time of measurement on 60.30 centimeter is the height, 48.50 is the width. Just on the same day, remeasurement 158.60 is the height, 2 centimeters increase. But the same is, and where is the increase? 50.70, 48. Who is that person? The said lady, one of the candidate. A party here? No. Then why we will look into that? If she has not chosen to assail one of those things, why should we go into that in somebody else's writ petition? Why should we? This is not a PIL, sir. Please try to understand. This is not a PIL.
You are here for a particular relief. You don't claim parity with that person. Then what is the point in looking into her example? She has accepted it. So therefore, how do we know what is wrong?
Process of measurement.
How it is relevant, that we are saying. Perhaps she has taken off the heels and got herself rechecked, therefore she is at home. How do we know how the height has decreased? If she was aggrieved, she would have come here.
She came here. Another.
Yeah, so she has not been successful.
Yes, yeah.
Then all the more no reason to look into it.
The process of measurement.
We are only you are aggrieved by a process of measurement. Your whole case is that in an earlier recruitment process, my height was assessed more than the present one. By the same board, maybe on the same machine. We take it that also. So what? Which measurement was correct? Exactly this we had observed on the last day, which is the reasoning assigned by the land single judge also. So which measurement was correct? This one or the earlier one?
Process of selection. Everyone was
That variation of 1 millimeter or what?
Everyone was selected to report by 7 a.m. These classes were measured at 8 p.m. But that, certainly that will differ. Therefore, there are process.
So therefore you are not alone. There are many others like you who have measured at 8 p.m. They would have been. See, the uniformity in the recruitment process is the hallmark of fairness. A uniform practice adopted for all candidates. There is no variation. There is no allegation of a specific malafide in favor of or against any candidate. So therefore, where is the scope? We cannot go into these issues in a writ petition. We should not be going. We should refrain from going. Insofar as appeal is concerned, you have availed the remedy. That we'll see what can be done. For those who have not filed the appeal, why did they not file the appeal? What have they said? What is their case in the writ petition? Please show what is the pleading. Don't make a submission, please.
Depart from making the appeal.
Why?
On the same this is their argument that some of the applicants could avail the forum appeal, but we were debarred from the availability of the appeal.
An appeal was to be filed online or before the...
Offline, by hand, on the same day.
So you came out of the center and you sent it by registered post? Nothing.
Initially, we went there for making the appeal. They refused. Thereafter, we came.
So on what day you were examined?
17 to 18 of there are several dates, 8 January, 17 January. By this time, the measurement of
So within period of 10 days, how many persons were examined who could not file an appeal?
15. Out of these appeal, 11%.
11 persons could not file the appeal and they were examined on 10 different dates. And how all the persons who are not similarly situated have joined in one writ petition? How can you do this? They should have been there, two different class of candidates. They have all joined in one writ petition. Create confusion for the everything. Extent. And then
Yes. Of which breed? Of nine. Yes. Which paragraph? Page 1. Yes. In the middle there are two statements. Data Roman H 151.40. Where 47 page. Now the next figure that is on 150.50. One same the same day by the same issue. No, she is not one of the petitioners. So her appeal has already been decided. Yes. Therefore, the measurement, process of measurement, that is carried out. Then there is something, we have missed something. We thought that the appeal was still pending, therefore the single judge has the appeal. 4 persons, they preferred the appeal. Their measurement was measured by the appellate authority. Yes. So then, that is not in this case. In 9, I am arguing on 10. Oh, one by one, it will be. Their appeal could not be preferred because of when they were accident. No. In these 4 persons, they were allowed to appeal. They are measured, process of measurement, same machine, one simulator use of the same. There is a common order for both the cases. So there should be one order, 2 errors. There should have been 2 repetitions. So 9 is for 1, 4, 5 and 6. All 4 have been found to be lesser in the appeal. Yes. All 4. For that reason, I wanted to like this. 2 taking weight on the same machine, 2 sending that is not relevant. That does not help you in any way. That does not help you in any way. That will only add to the bulk of the brief for no purpose. She has emerged unsuccessful in her legal battle. So that whatever was the result has now crystallized, it has become final. There is no way that you can allege anything based on that. Yes. The same. This is referred to perhaps in the judgment of
So you are relying on this for 10, not for 9.
Selection where we are qualified. The base 8
They have got no relief from the single. They have not got any relief because they were already tested twice. Fail also. Therefore, we are wondering how you have clubbed all these things. You are relying on a judgment for some of the petitioners which destroys the case of the others. Because the Delhi High Court has said that whatever appellate authority will do, they will accept it as final and binding. And you are trying to challenge the finding of the appellate authority for some petition. What 910 writ petitioner is one and the same. How you have clubbed two people who have different class in a one writ petition, we don't know. It has been considered also. They are mutually destructive team amongst the petitioners themselves, and they have been joined as one. Anything else? You want to show anything else?
Only this chart which I have handed over to your lordship earlier,
What is that, sir?
that the appellant number 1,
Part of the writ record.
everything is in the record, but I have prepared a chart. Page 80, the 2020 selection.
That they are not disputing that there is a variation.
Yes.
Whether that can constitute a ground to reopen the issue, that is only. But actually, there is no dispute. They don't say that in the earlier round you were not measured. Maybe having a variation of a few millimeters or half a centimeter or 1 centimeter.
Well,
That they are not denying and disputing. They are saying this cannot be made.
they are declared fit physically. Now, by 3-4 years, we are reducing 2 centimeter, 1 centimeter by the same machine. How it is possible?
That we have understood.
Well, everyone should be given the similar chance, because one person is measured at 7 a.m. and same day the person who is attending at 7 a.m. being measured at 8 p.m. By this time there may some variation. Everybody should be given the reporting time when they will be measured. And if the appellants are remeasured, there will be no, there will be no prejudice.
Yes, sir. Therefore, yes. Order should be set aside that item number 10, that part of entire appeal and the measurement, that part would be set aside, only this. As so far item number 9 is concerned, I will make a prayer to dismiss the appeal. Nothing more than that. But only one thing, there's nothing, there's a very lighter note. That I have said on the other day, changes are there, morning, evening changes are there. With the age, changes are there. With the age, changes are there. No, every 2 months, after 2 months or 3 months, I have to change my pant because of the weight. That we know when we are aging. It depends on time, depends on age. Even 3 months change. And in older days, it is a great change. That is, we lose weight, we gain weight. We don't know when which date we will gain weight, we know which date we will lose weight. Such bottle. Can I give you a blessed tell us, grateful tell us?
তো বন্ধুরা নেক্সট আর একটা ভিডিও আসছে, তোমরা অপেক্ষা করো। গুড নিউজ তোমাদের আমি ভিডিওর মাধ্যমে দিয়ে দেবো। অবশ্যই চ্যানেলটিকে সাবস্ক্রাইব করে রাখো।